one interesting thing was then the public charge rule came, and of course, going back and forth on it, the updated public charge rule. Illinois was one of those places that had its own decision. So how confusing was it for you guys in Illinois when you're getting like local marriage cases filed there? Whether it's filed that old 9994, whatever it was called, or was that a headache when they undid it, do it? That must have been madness when if you're in Illinois.
Honestly, that's such a fantastic question. I'm paranoid. I'm paranoid, and I tend to go above and beyond. And sometimes I drive my clients crazy because I push them so hard to give me everything that I need. But at the end, they appreciate it because they realize why I was doing it. But to your point, I never stopped submitting the I-944. Even when we were told that, okay, this week you don't have to submit it, I'm like, you know what? I'm going to submit it. Worst case scenario, they're just not going to look at it.
Exactly.
And so it's always better to be over prepared as opposed to saying, okay, well, I don't need to do this week, but I might have to do it next week, because you never know. Even when you comply, even when you do things exactly as instructed by USCIS, you just don't know who is going to be reviewing your file, whether they've been trained properly. You never want that packet to be sent back to you. So might as well just do more work, and you'll be better off for it.
It was such a peculiar situation because like one state out of the union didn't have to do it, and in the mailroom they're not necessarily going to pay attention to see where their jurisdiction is, and that could easily be. I mean, I see people getting rejection notices for I had one rejection notice for I-751 where they said the person didn't sign it, and they sent it back with those stamps at the bottom with the signatures right there. I'm like, well, what's going on here? So you got to always prepare for the worst. It's unbelievable the things that you get back sometimes.
Exactly. And, the article that I ended up submitting to your magazine talked about, how to prepare for interviews, and the same thing. One of the main questions I get is, well, wait a second, we gave them a ton of evidence. Why should I give them more? And so the idea is that you have to throw the kitchen sink at them to the point where I actually had an officer tell me, you know what, counsel, no more, please, no more. I'm good. And so I loved hearing that. I loved hearing that because that's exactly the type of preparedness that I think clients should go into these interviews with. And any of the young lawyers listening, don't ever take the path of least resistance. Always take the harder road. Always do more. Not only will you get good reviews from your clients, but USCIS officers are going to really, really appreciate how meticulous you were, how much attention you paid to the nitty-gritty parts of the case. And if you do that, I think you'll be better off.
Another aspect that comes into play, the importance of, to me, overpacking the evidence is more and more I see USCIS at not only the I-751 stage, but at naturalization, looking back to marriages, especially if they've gotten divorced, to try to question things and say it was fraud. So the more you have in the past, the better it is for a client in the future, because they're not going to hold on to these documents. The other spouse might have it. So you're just doing them a service of, having, a good foundation. So there's no coming back later and saying it's a problem. Like I have cases, people come to your consultations where they filed an adjustment case like in 2005. And then while the case was going, they got divorced and they just stopped it. They don't get an NTA or anything. 10 years later, they marry a U.S. citizen. And at that interview, they say you did fraud previously. At that point, 2005, it's like 10, 15 years ago, they don't have the documentation to protect themselves, and there's not as much email history and all that kind of stuff. So if we do a FOIA and we see like a packed I-130 with a lot of evidence, that can help overcome these bogus fraud claims that they're really pushing. And not always bogus, but I think it's too much the way they're doing it. So it helps the client, even if they don't understand it, but you're kind of like plan B, C, D, E, F, and all down the line. That's what we're getting paid for, to be extra cautious about everything.
Absolutely. And one of the things that we've noticed, especially as it relates to certain countries, is that certain countries are under a greater microscope. They're being scrutinized far more than other countries. And so when you are meeting with a client and doing the intake, make sure that you ask probative questions, tough questions, because you don't want to be in a situation where you're going to be surprised at the interview, for the adjustment interview. We had a situation where thankfully, we didn't handle this case from the onset. But anyway, it was a different law firm. The person goes to the adjustment interview, and the officer says, "Sir, how many times have you been married?" And kind of confused, this beneficiary says, "Well, once," and she's sitting right next to me. And he goes, "Sir, are you sure?" It was, "Yes, I'm pretty sure. I think I'd remember how many times I've been married." And so the officer turns around, pulls out this huge folder stemming from the consular processing, where the person had applied for a visitor visa. And in that visa, it was noted that not only were they married, but they also had a child.
Mm.
And so they came to us for help. And sometimes you can't avoid those situations because the person was less than truthful with the government. And so now you're looking in a situation where you have to show extreme hardship to a
Yeah.
spouse, the current spouse, in order to overcome certain transgressions that the individual had made previously. So those situations, yeah, they're going to come up. You can't help it. It is what it is. But other than that, you really have to do your due diligence in order to understand your client's case inside and out, to make sure that there are no surprises down the road.
That issue pops up more and more with the DS-160s because their accumulation of data and ease of transferring to USCIS has gotten better, so they can review that kind of stuff. And one issue is some lawyers do a FOIA for every case, both USCIS and DOS, and with the delays in FOIA and whether the Department of State is going to actually release the FOIA and how long that's going to take, it's always like a fine line. I got to really read the client. I'm like, is this going to be a DS-160 issue? Like I have this where they don't tell the government they had military conscription, for example. And I'm like, well, did you tell them? Like, I don't know. But I'm like, how do you know? There's a question that says, have you been in the military? Do you have any military training? You got to tell them they asked that, and they don't know. Then we have to do a FOIA. But it's something to be very careful of.